So I believe we will now start with tonight's session. And as previously announced, tonight's session regards the issue of diplomatic and consular law. In this occasion, I will be presenting this subject to you. As I mentioned before, my name is Juan Pablo Hernández. I am the co-administrator for Guatemala for the Jessup competition. And for those that were not present in the last session, in the first session regarding Introduction to Public International Law, I am also working in the Foreign Ministry of Guatemala as a diplomat and in charge of Guatemala's foreign policy regarding international law. And so the subject of tonight's session actually concerns an issue that is very close to one of the questions presented by next year's Jessup case. And therefore, some of the issues that would usually be involved in the assessment of this subject will not be addressed here. Particularly, the focus of this lecture will be on the concept, the nature, and the extent of diplomatic and consular immunities. As ever, if you have any questions, you can write them in the chat. And there will also be a section at the end of this lecture for you to make any further questions that you may have regarding tonight's subject. And so unless there are any initial questions, we will begin with tonight's subject. And as I mentioned, tonight's subject relates to diplomatic and consular immunities. It will be developed in the following order. First, we will analyze the nature of diplomatic and consular immunity as a subject of public international law. And this will be analyzed from or through the lens of international law regarding jurisdiction. The second subject will relate to the theory behind the concept of diplomatic and consular immunity. And this will concern both consular immunity and diplomatic immunity interchangeably, and where there may be any differences, as they, of course, are many, they will be pointed out. So take that in mind and take that into consideration. During the third part of this lecture, we will address the functions and the inviolability of the diplomatic mission and some of the areas of diplomatic law that are related to it, including issues regarding the freedom of correspondence, the protection of documents and archives, and the protection of the diplomatic bag. And finally, we will be addressing a very hot topic in the issue of diplomatic and consular law, which relates to the issue of diplomatic asylum as a subject of international law. And with that, we will close tonight's session. So it is anticipated that this session will last about 1 hour, 1 hour and a half, and we will have plenty of time for questions in case you have any. So perhaps the perfect place to start when one addresses the issue of diplomatic and consular immunity and diplomatic and consular law in general is to analyze what is its status within the international system. And so, of course, it would be a mistake to say that the relevance of international diplomatic and consular law is limited to the issue of jurisdiction. However, the easiest way to understand how these immunities function is to first start with this subject, with the subject of the jurisdiction of states according to international law. And so jurisdiction, and here I refer specifically to jurisdiction as pertains to the power of states, and not jurisdiction as relates to the competence of international tribunals to adjudicate and solve disputes at the international level. Jurisdiction, in the sense of the power of states, relates to the power to create, modify, and terminate legal relations that impact persons, property, and situations. In other words, it refers to a legal power of states to establish obligations and rights for people and to terminate them. And so this concept of jurisdiction is one of the inherent powers of states. It derives directly from the equality of states, the sovereign equality of states, and the principle of non-intervention. For those that were not present in our first lecture, which related to the introduction to public international law, the principle of sovereign equality and the principle of non-intervention is one of the key pillars of international law. It is recognized in Article 2, Paragraph 1 of the Charter of the United Nations, and as pertains to the principle of non-intervention, it is recognized as a principle that forms part of customary international law. And this was stated by the International Court of Justice in the Nicaragua case, as well as many other decisions over the years. And so the basic tenet behind the question of sovereign equality and non-intervention is the notion that states have sovereignty over their own territory, and that within their territory they have certain rights and obligations that do not concern or do not impact the relations between that state and other states of the international system. And thus it is understood that these aspects that fall within the jurisdiction, the domestic jurisdiction of a state, pertain only to the state, and the state is free to regulate them and to enforce them. And it is in this context that we see the relevance of diplomatic and consular law. Because from the theoretical perspective, there are many ways in which we can understand this jurisdiction, this power to create, modify, and terminate legal relations within the sovereign powers of a state. Some have argued, and this is based on the Montesquieuan theory of the separation of powers, that jurisdiction itself has multiple archetypes that are divided into executive power, judicial power, and legislative power. These three components of jurisdiction can be understood, as I mentioned, by reference to the Montesquieuan theory of separation of powers, in the sense that a state has legislative power to enact law, or law understood in its material sense, in the sense of acts of power that regulate legal relations. The state has the power to interpret and prescribe conduct according to those laws, which would be the power to use the judicial functions of the state. And finally, that the state has the power to enforce that law, to take the decision rendered in accordance with those laws and to make them positive within its territory. That is to say, it has executive power. This classification of the notion of jurisdiction can indeed be criticized in many respects. One of them may be that not every state can be understood as dividing all of its public functions within these three paradigms. There may be some states that have further paradigms, for example, those that have a fourth power that relates to the power of control, which has been connected to the ability of certain institutions to control the exercise of public power. And thus, to prescribe this classification of jurisdiction as concerning only executive, judicial, and legislative power is not only in a way reductive, but it also can be seen as impacting in a way the ability of states to regulate their own internal structures in the way that they deem appropriate. And thus, the classification that many authors advocate for from this perspective is simpler. They divide jurisdiction between two categories: the power of states to prescribe conduct, that is to say, prescriptive jurisdiction, and this would encompass both the power to legislate, the legislative power, as well as the power to apply those laws and interpret them, which would be judicial power. And on the other hand, the issue of the power of states to enforce that law, that is to say, enforcement jurisdiction. And you will see that this classification is not only very well accepted in the international literature, but it is also a very helpful classification when one addresses the issue of immunities from jurisdiction, which are also, from a general theory of immunity, divided into jurisdictional immunity and executive or enforcement immunity. or as it is also called, immunity from execution. And so it is this classification between prescriptive jurisdiction and enforcement jurisdiction that is most helpful in this respect. Another important aspect of jurisdiction is that jurisdiction is primarily territorial. And here I use the word primarily very carefully. This is the term that is utilized by the International Court of Justice in its 2004 Wall Advisory Opinion at paragraph 109, as you can see in the screen. And the reason why it is considered to be primarily territorial is because in some instances, international law recognizes the power of states to apply their prescriptive jurisdiction outside of their territorial boundaries. And here again is an aspect where the classification of jurisdiction between prescriptive and enforcement is particularly helpful, because according to the views of very many publicists in international law, prescriptive jurisdiction has a freer range to be applied extraterritorially, in the sense that under international law, there may be instances where it is recognized that if the interests of the state are impacted in some way, for example, where a certain act has affected a national of the state or has affected the security interests of the state, there may be some latitude for that state to exercise prescriptive jurisdiction in the sense of applying its laws extraterritorially and interpreting them and applying them in individual cases. Where there is some obstacle from the legal perspective is where one addresses the issue of enforcement jurisdiction, executive jurisdiction, because a state is not permitted to exercise its executive powers outside of its territory without the consent of the other territorial state. You can see this from the perspective of the prohibition of the use of force or the threat of force, which is established in Article 2.4 of the Charter of the United Nations. And it is also a principle that is related to the notion of non-intervention, in the sense that a state is not allowed to substitute its own public functions for those of the territorial state. And thus, there is a distinction to be made here regarding the territorial scope of jurisdiction. And this is particularly relevant in the realm of international criminal law and also transnational criminal law. For example, transnational criminal law instruments establish mechanisms for developing cooperation in judicial matters between states so as to avoid the situation in which one state decides to utilize executive power outside of its territorial boundaries. And if you see conventions such as the United Nations Convention Against Corruption or the United Nations Convention Against Transnational Organized Crime, you will see that there are express provisions where they safeguard the sovereignty of states and the exclusive exercise of jurisdiction between the territory. In this respect, one of the most important concepts, as I mentioned before, is the concept of domestic jurisdiction. This concept of domestic jurisdiction will be related in some way with the notion of domaine réservé or reserved domain. And this relates to a scope of matters that under international law are considered to be only within the purview of the territorial state. That in the exercise of its power, this state is entitled not to be interfered with. And this notion of domestic jurisdiction for some time was considered to be rather extensive or even absolute, in the sense that the relations between the state and its subjects were considered to be outside of the interest of international law. You can see this in some decisions of the Permanent Court of International Justice. For instance, there are many advisory opinions where the court analyzes the notion of domestic jurisdiction and analyzes whether the concept of domestic jurisdiction is limited by the enactment of international obligations regarding certain matters. And the court points out that this issue depends on the international relations of the state. Therefore, it is something to be looked upon through the lens of that state's specific situation. Now, what we see in modern times is that the notion of domestic jurisdiction has contracted in a way. The International Court of Justice has recognized that the exercise of domestic jurisdiction is rather free, except where it impacts the sphere of international law. And the sphere of international law is ever expanding. We see that especially in the aspect of human rights law, which we will analyze in the context of the notion of diplomatic asylum. And you will also analyze it, I believe, tomorrow, where we have a lecture regarding human rights law in particular. And to further explain this point, we can see some pronouncement by the International Court of Justice in two cases. The first is the Nottebohm case in 1955 at pages 20 and 21, where the court is analyzing the legality and the opposability of the granting by Liechtenstein of a naturalization in respect of Mr. Friedrich Nottebohm. Without delving too deeply into the issue of naturalization, which, as I mentioned before, is an issue that concerns the present Jessup problem, the court analyzed that the naturalization of Friedrich Nottebohm was a unilateral act performed by Liechtenstein in the exercise of its domestic jurisdiction. It was performed in the exercise of Liechtenstein's internal law, and therefore, in principle, international law has nothing to say about it. However, where the unilateral act, that is naturalization, impacts the sphere of international law, there, the issue is not to be resolved according to domestic jurisdiction and domestic law, but rather according to international law. And the court says particularly that to exercise protection, and here diplomatic protection, and to apply to the court, to present a claim to the court, one places oneself in the plane of international law. And therefore, it is international law, quote, which determines whether a state is entitled to exercise protection. And thus, the question in that case was whether the act of naturalization had any international effect. A similar example is the ICJ's decision in the Norwegian fisheries case in 1951 at page 116, where the court stated that the act of delimitation of territorial waters is a unilateral act. It is up to the state to determine it, but the validity of the determination as regards other states, that is to say, its validity when it impacts the sphere of international relations, then this validity is to be analyzed from the perspective of international law. And it is against this backdrop that one needs to understand diplomatic law. Because immunity, which is how many publicists analyze the issue of diplomatic law, is the reverse phenomenon from jurisdiction. It is a carve-out from jurisdiction. And therefore, it is a phenomenon that needs to be placed within its proper context. According to many authors, for example, Malcolm Shaw adopts this position, as well as James Crawford. The issue of immunity presents some complications as a carve-out from jurisdiction because it is grounded on the very same ideals. As I mentioned before, the issue of jurisdiction is grounded on issues of sovereignty, sovereign equality, domestic jurisdiction, non-interference. And in that same sense, immunity from jurisdiction and immunity from enforcement is based on the same principles. And we can see this in the context of state immunity and the immunity of foreign officials, where it is understood that the sovereignty of the state, in a way, maps out to encompass the protection of certain international actors from the exercise of jurisdiction by states that have no link of nationality with them. Of course, our lecture today will not concern the issue of state immunity or the immunity of foreign officials in general. We will be delving specifically into the issue of diplomatic and consular immunities and diplomatic and consular law in general. But it is important to understand that these subjects fall within this theoretical scheme. And in this respect, it is important to understand what is the theory behind the privileges and immunities of diplomatic and consular posts and missions, agents, and property. What needs to be understood in this respect is that diplomatic law, as a field of international law, is, according to very many experts, one of the earliest expressions of international law. And what we can see when analyzing diplomatic law is that it is grounded on principles that are rather simple, but when one applies them to the facts of different cases, they become very complex. The basic principle of diplomatic law is that international law, as the body of law that governs international relations, has a vested interest in the protection of means of communication. That is the basic principle that underlies diplomatic law, and to some extent, consular law, although consular law involves other aspects which will be analyzed subsequently. And so, since international law has a vested interest in the protection of mechanisms of communication, then international law establishes mechanisms itself for those means of communications to be respected. And every single one of the immunities that are recognized under international law for the diplomatic mission, the diplomatic agent, diplomatic documents and archives, correspondence, and the diplomatic bag are all directly or indirectly connected to this ideal. And this is a principle that is very firmly established in the practice of states. One example that can be seen in this respect is the oral arguments and the written arguments presented by the parties in the Notevum case. For those who may not know, within the Notevum procedure, one of the issues that was presented before the court was whether Liechtenstein had exhausted diplomatic means of negotiation before resorting to the court. Guatemala's argument as a respondent was that international customary law obligated Liechtenstein to exhaust diplomatic negotiation before going to the international adjudicative sphere. That is to say, before presenting a claim before the International Court of Justice. And the dispute between the parties in this respect, in this first preliminary objection, was whether international law not only required for certain negotiations to be exhausted before a dispute could be said to arise, but also how those negotiations needed to be carried out. And the argument of Guatemala was that many, or if not all, of the communications engaged between Guatemala and other states regarding the protection and the treatment of Mr. Friedrich Notevum were between Guatemala and Switzerland, and not between Guatemala and Liechtenstein. And that in any event, these were consular communications, not diplomatic communications, and therefore they did not fulfill the standards set out by international law according to Guatemala. The position of Liechtenstein in this respect was that international law did not provide for any requirement that official communication needed to take any special form, that the specific criterion to be looked for in the practice of states was whether proper state representation was present. And that was it. Liechtenstein's argument was that under international law, diplomatic communication did not need to take place only through diplomatic agents or through the mechanism of diplomatic missions. Rather, official communications between, for instance, ministers of foreign affairs, heads of state, heads of government, special representatives before international conferences, and of course, consular agents and consular posts were to be recognized also as falling within the technical concept of diplomatic communication. And so the scope of this protection was envisioned to be very broad. And we see this in some aspects of protection, which will be addressed in a later slide. Another important aspect in the theory of diplomatic law and privileges and immunities is that the corpus of international law in this respect is regulated in two main conventions. There are other conventions, many of them prior to the enactment of these conventions, regulate the issue of bilateral or from a bilateral or multilateral aspect, the relations between states and their communication. However, the main conventions in this respect are the 1961 Vienna Convention on Diplomatic Relations and the Vienna Convention on Consular Relations. These conventions in this respect can be recognized to be, in many respects, codifications of international law or customary international law in particular, with some exceptions. For instance, some authors like Professor Bandera Galindo from the International Law Commission has expressed the view that much of the regulation regarding the diplomatic bag is not part of customary international law, for instance. But most of these conventions, and perhaps the most essential parts of these conventions, are to be considered codifications of customary international law. And this was recognized by the International Court of Justice in the 1980 Tehran hostages case. Now, some of the salient aspects of diplomatic law are the ones that will be explained as follows. The first is that under international law, there is no right to diplomatic relations. In other words, international law does not contemplate any obligation on states to engage through diplomatic relations in any way. International law recognizes that the cornerstone of diplomatic relations is mutual consent, that is to be established between states and is to be respected within those boundaries, within the boundaries of consent. And the concept of jus legationis, or the right of legation, is rather recognized as an expression of the capacity of states to enter into diplomatic relations with other states. And as you may know, this is one of the key attributes of a state, according to the 1933 Montevideo Convention on the Rights and Duties of States under international law. Another important aspect that evidences this consent-based system is the concept of persona non grata. We will be analyzing persona non grata later, but it is an evidence of the reciprocal nature of diplomatic law in the sense that no state is obligated to accept any particular diplomatic agent. A state is free under international law to recognize or not a certain diplomatic agent. And if a diplomatic agent is not considered to be suitable for any reason, a state has a right, recognized under Article, I believe, 9 of the Vienna Convention, to declare that person as non gratus, and therefore to be expelled from the territory of the state and not recognized as a representative of the other state. This will be analyzed subsequently. Now, what is really the theoretical grounding of diplomatic immunities in this respect? What one can point out in this context is that there are three basic theories that describe the grounding of diplomatic and consular immunities. The first theory is the theory of exterritoriality, also called the theory of extraterritoriality, which is a jurisdictional fiction, according to which the premises of the mission is to be regarded as not part of the territory of the territorial state, but rather part of the territory of the sending state. And therefore, these immunities accrue by virtue of the respect for the territorial integrity of another state, rather than any consideration of the functional necessity or the representative character of the agents and the mission. And so, as you can understand, this is a jurisdictional fiction, that it tries to establish a carve-out from jurisdiction of the territorial state by negating it altogether. This theory might be rather popular. Some people, for instance, in the news and in movies may say, and you may hear, that people say that embassies and consulates are not considered to be territory of the territorial state, but rather they are foreign soil in a way. This is very important to understand as not part of international law as it presently stands. This theory of exterritoriality was considered during the debates of the International Law Commission regarding diplomatic and consular intercourse between states, and it was rejected. Rather, the grounding of diplomatic immunities and privileges under international law can be found in a mix between two theories. The first is the theory of functional necessity, and the second is the theory of representative character. These two theories have a certain degree of normative overlap, in the sense that functional necessity refers to the need for some rights and some immunities to be recognized because they are considered to be necessary for the development and exercise of the functions of a foreign agent. And on the other hand, the theory of representative character says that these rights and immunities need to be recognized because they are the expression of the recognition that this agent and this mission is a representative of a foreign state. Therefore, that person represents the sovereignty of that other state. So both of these theories, in some respects, are recognized in the Vienna Convention on Diplomatic Relations. They are both grounded on the idea that one can recognize as an objective parameter an act of a state under international law. And this can be an act of an agent that exercises diplomatic functions. If you see the VCDR preamble, it is stated that immunities are granted to individuals, but not in their individual capacity, but rather by virtue of their functions as representing states. And therefore, we see the element of functional necessity on the one hand, and the notion of representative character on the other. And as I mentioned before, the ICJ recognized in the Tehran hostages case that most of these rules on diplomatic immunities and consular immunities are to be considered part of customary international law. Now, some aspects that flow out of this recognition of immunities is that one needs to understand what is the subject of the immunity, who is entitled to this immunity, and this is what we will be analyzing for most of the presentation today. The first question is, what is a diplomatic mission? And the reason why we need to ask this question is because the diplomatic mission is not defined in the terms used under Article 2 of the Vienna Convention on Diplomatic Relations. And therefore, this complicates the identification of who is entitled to such privileges and immunities. One of the proposals that we can find in the doctrine, and this is a proposal that was made by Professor, as I mentioned before, Bandeira Galindo, who is a member of the International Law Commission, is that the concept of diplomatic mission needs to be analyzed from the perspective of the functions of the mission. In this respect, the functions of the mission are to be found in Article 3 of the Vienna Convention on Diplomatic Relations. The basic ones can be seen on the screen. Essentially, to represent the sending state, to protect the interests of the foreign state and its nationals, to serve as a mechanism or a means of negotiation with the territorial state, to ascertain and report to the sending state relevant developments in the territorial state according to international law, and finally, the promotion of friendly relations in many areas, which may be, for instance, the economic realm, as well as the political realm. So these are the functions of the diplomatic mission. And therefore, according to the proposal of many authors, this is what we need to take into account in order to define what is a diplomatic mission. Other authors give us hints as to how one is to understand what a diplomatic mission is. For instance, Maresca argues that a diplomatic mission has three components that are important from a theoretical perspective. The first is that the diplomatic mission is an institutional body. It belongs to the institution of the sending state, but in a way, the institution of the diplomatic mission is an aspect that concerns the international community as a whole. And therefore, it is, in the words of Maresca, an institution that belongs to, or rather an institution of the international community. At least the concept of diplomatic mission rather than the mission itself. The second is that the diplomatic mission is understood to be permanent. in the sense that it assures the doability and continuity of diplomatic missions and diplomatic relations themselves. And finally, diplomatic missions are complex bodies because they summarize a plurality, in the words of Maresca, quote, plurality of legal values of international relevance. These legal values are the ones that I have expressed previously regarding the protection of sovereignty, as well as the furtherance of friendly relations between states. And what about the consular post? The consular post can in a similar way be defined by reference to its functions. And the functions of a consular post are very different. The consular post, of course, does have the element of protecting the interests of the sending state and its nationals, as well as the development of friendly relations. However, the difference between a diplomatic mission and a consular post is that while the diplomatic mission is intended to promote the representation, the negotiation, and the ascertainment and reporting of the situation in the territorial state, that is to say, it is intended to develop the relations between the sending and the receiving states, the consular post is rather focused on the performance of certain services for the nationals of the sending state. In other words, the functions of the consular post are have a focus that is more administrative in nature. And therefore, this is how one can define the distinction between consular posts and diplomatic missions. Now, one of the concepts that is most tricky in the context of immunities and privileges is how one defines the boundary between an immunity, a privilege, and an inviolability. I don't know if any one of you that is connected today would be brave enough to venture a guess as to what is the difference, for example, between an immunity and a privilege. This is an open question. I don't know if anyone wants to answer it. If anyone wants to, they can open your mic and give us your reasoning about it. Let's see if anyone dares to do it, at least from a legal perspective. No, I don't see. Perhaps I see Viana making a reaction there. I don't know if Viana, you want to give us a brief explanation of what the difference is in your view between immunity and privilege?
I appreciate the opportunity, but I would rather you explain your professional vision on it.
All right. So the answer is that under international law, the distinction is not very clear. The distinction is not very clear because many international instruments and writings and decisions use these terms interchangeably. And therefore, it is very difficult to draw a distinction between them. One of the ways to draw distinctions between the subjects would be to go back to the debate in the International Law Commission in 1957, when the convention was being drawn up from a legislative perspective. And while the VCDR doesn't have any definitions of inviolability, immunity, or privilege, these concepts can be, or the difference between these concepts can be gauged by looking at the position expressed by one of the members of the commission, which is Professor Ferdros. Professor Ferdros conceived of the distinction between these three concepts as follows. First, a privilege is a right that is enjoyed by the sending state. And he considers this concept to be very broad. It is a general terminology that encompasses a very broad spectrum of rights. An immunity is a more specific concept. An immunity, as I mentioned before, is a right that has the specific purpose of derogating from the territorial jurisdiction. It prevents the exercise of authority by the receiving state over the diplomatic mission, its members, its property, its documents, its archives, and its correspondence. And so this would fall squarely within the concept of an immunity from jurisdiction. And as you can see in the Vienna Convention on Diplomatic Relations, it also falls within the concept of immunity from execution, because the property of the mission has and does enjoy some immunities from execution in the context of international law. And one important aspect in respect of immunity is that it doesn't always refer to immunity from the jurisdiction of courts or administrative tribunals. As I mentioned in the first slide, and that is why it is important to understand the concept of jurisdiction. Jurisdiction is an ample subject. It not only encompasses judicial or administrative jurisdiction in the sense of solving disputes between parties, it also refers to the power of a state to proscribe and prescribe conduct. And so it would also fall outside of the legislative function, the judicial function, and the executive function. And within this context, this backdrop, an inviolability is a more specific type of immunity. It is a subset of immunity that flows from or derives its special character from the duties that arise for the territorial state and also for the sending state. And this is where we will go directly to the duties of both states under international law. Because Article 22 of the Vienna Convention on Diplomatic Relations tells us that the mission premises are, quote, inviolable. They are inviolable. And according to the understanding of this concept in international law, inviolability encompasses positive and negative duties that derive for the territorial state. And it also derives certain duties for the sending state's agents in that territory. We will address those duties in I believe it is the next slide. But before we analyze those duties, one needs to analyze when those duties start. Once again, like when we analyzed the demarcation between immunity, inviolability, and privilege, the answer is not clear. Some say that the inviolability starts when the mission itself is installed in a certain premise, and therefore it starts functioning. And the reason why people say that this is the case is because the purpose of the immunity is to protect the functions of the mission. As I mentioned before, the theory of functional necessity. Now, the second theory says that inviolability starts when the premises of the mission are put at the disposal of the sending state, even if official functions have not begun to be undertaken yet. And so, for example, when the state says, so this is the premise of the mission, this is where we will be set up, we will start to let's say to furnish the place, to transfer the diplomats, etc. At this stage, this preliminary stage, before the exercise of functions, some say is when the inviolability starts. And the reason why they say this is that if the purpose of the inviolability is to protect the functions and the representation, it would be inappropriate to say that international law would allow the territorial state to interfere with those functions when it is clear that those functions are going to be exercised, but they are not being exercised yet. And the third theory says that the inviolability starts when, as early as the moment in which the state notifies the other state of its intention to establish the mission in a particular place. And so this concept of when the inviolability starts has not yet been analyzed fully by the International Court of Justice or the International Law Commission itself. As far as I know, there is no positive and universally accepted concept of when inviolabilities start. One particular aspect that may be relevant is the ICJ's decision in 2020 in the case concerning immunities in criminal proceedings. This was a case between Equatorial Guinea and France. It concerned a case in which France refused to recognize Equatorial Guinea's designation of a certain building as the premises of the mission in Paris. And the distinction that was drawn in the discussion of this case was based on the principle that the diplomatic relations are established on a mutual consent basis. And so if mutual consent is the guiding principle here, then mutual consent should also be required when designating the building that will serve as the diplomatic mission's premises. On the other hand, the argument of Equatorial Guinea was based on the principle that to allow the state, the territorial state, to exercise some sort of veto power would be to allow that state to interfere with the exercise of public diplomatic functions. The majority of the court expressed the view that the answer to this question was to be found in an intermediate position, but this intermediate position was closer to the notion of mutual consent rather than the notion of the free and unencumbered exercise of diplomatic functions. And so the court said that in some instances, the receiving state may refuse the designation of a particular building as a diplomatic mission, for instance, through official guidelines, through legislation, or even in a case-by-case basis when this is not considered to be appropriate. However, this is not an arbitrary or absolute right. In other words, this is not a veto right on the head of the state. Rather, the exercise of this principle needs to be taken in conjunction with the idea that diplomatic missions are intended to promote friendly relations between states, to allow for communication, and to protect the functions of the mission and its members. And therefore, this right could not be exercised arbitrarily. It had to be exercised timely through reasoned objections, and these objections needed to be based on the idea that diplomatic immunities were intended to further friendly relations between states. And so according to the International Court of Justice, the French position in the French way of implementing this power of objection was in accordance with the Vienna Convention on Diplomatic Relations. So this power of objection to the designation of a place as the diplomatic mission's premises does give us some insight as to how this answer is to be given under international law. Perhaps the court didn't tell us when inviolability starts, but it does say that the territorial state has some power to object and some duty to negotiate with the sending state as to the positioning and the start of the exercise of functions for the diplomatic mission. Of course, this is not a practice that is undertaken every time. This is not very common. In fact, the court itself said that the state practice relating to the prior approval by the territorial state was not in any way uniform. It could be taken into account when interpreting the convention, but it was not a binding practice between the parties. Now, what duties arise for the territorial state regarding or out of or by virtue of the inviolability of premises? There are three basic obligations. Two of them are codified in the Vienna Convention on Diplomatic Relations, and the third one is uncodified, but according to many authors, is a duty under customary international law that naturally derives from the duty to protect. And so the duty to protect says that the territorial state has the obligation to, as the term says, to defend, to protect the dignity and the integrity and the freedom, as well as the unencumbered exercise of communication by the diplomatic mission and its members. In other words, the state has the obligation to ensure that third parties do not interfere with the exercise of diplomatic functions. The second duty is a duty to abstain. In other words, the territorial state has the obligation not itself, through its agents, to interfere with those functions. And deriving from these duties, the state has the obligation to not only ensure that these functions are exercised freely, but also that anyone who infringes upon those functions is sanctioned according to internal law, so as to ensure that the protection is effective. And so those are the three functions that derive from immunity, and particularly inviolability. From these three duties, one can also surmise, and this is codified expressly in the Vienna Convention, an obligation for the territorial state to respect the integrity of the mission and its dignity, and therefore not to enter the premises of the mission without the consent of the head of the mission. Now, these are very extensive powers. This is a very extensive derogation from the jurisdiction of the territorial state. And therefore, there is a counter duty of sorts, a counter obligation of sorts for the mission and its members to respect the laws and regulations of the territorial state, and the duty not to interfere with the internal affairs of that state. So this is a very careful balance that is struck by the convention. On the one hand, the mission is free to exercise its functions, but on the other hand, the mission is not free to, through the exercise of functions, violate the territorial laws or interfere with the exercise of the state's own jurisdiction. So in this context, one needs to analyze whether there are any exceptions to the inviolability of a mission. The question in this respect arises because the Vienna Convention on Consular Relations does contemplate some instances in which the public authorities in the exercise of law enforcement can enter the consular post without consent for reasons of emergency. For instance, when the consular post is on fire and the public authorities need to do something both to protect the mission and its members, as well as to protect the vicinity. So should there be any exceptions? And are there any exceptions under customary international law? And the answer appears to be that there isn't any. There isn't any exception, because the Vienna Convention on Diplomatic Relations doesn't contemplate a right to enter the mission and its premises without the consent of the head of the mission in cases of emergency. It also doesn't allow the state, or the territorial state, to exercise law enforcement functions within the premises of the mission. And one of the questions that may arise in this respect is whether these protections subside in some way when one is met with a rule that is of a superior hierarchy. For example, a rule of jus cogens. This is a question that is not answered in the international jurisprudence, but some guidance can be found in some cases that relate to other kinds of immunities. For example, in the 2012 jurisdictional immunities of the state case between Germany and Italy, the court said that the International Court of Justice said that there was no universally acknowledged exception under international law that in cases of violation of jus cogens obligations, the immunities of a state subside and allow for other states to sue them in national courts. And so the reason why the court says this is that immunity is in some respect a right that is of a procedural character. It prevents the exercise of jurisdiction. And so it doesn't provide for an exception for responsibility. And since there is no exception for responsibility, then the immunity doesn't conflict or collide with jus cogens. It only provides for the exclusion of certain procedural mechanisms. And since international law recognizes other procedural mechanisms, then there is no collision and the immunity doesn't subside in the face of jus cogens. This decision has been criticized immensely in the legal literature. And the court has the opportunity in a present case between the same parties regarding similar conduct to analyze whether this decision should be overturned in any way. This is something that falls outside the scope of this session. However, what is relevant in that case is that since immunities in this case, in the case of diplomatic and consular law, is also in some respects a procedural right, a procedural mechanism, then one could easily draw the analogical conclusion that a collision with jus cogens would not, in a case-by-case basis, allow for the violation of the immunities of the mission premises. Now we will address some specific areas of protection under international law. Perhaps the most salient one is the protection of documents and archives. I want to clarify that I will not be delving into the protection of diplomatic agents in this case, because I want to avoid as far as possible the reference to the current Jessup case. So I will only be addressing the protection of certain documents, archives, property. And first, to analyze documents and archives. So the protection of documents suffers some duplication in the Vienna Convention on Diplomatic Relations. The reason for this is that according to Article 40 of the Vienna Convention on Diplomatic Relations, document protection applies everywhere and anytime. In other words, the temporal and territorial scope of documents is very ample, is very broad. And at the same time, the Vienna Convention recognizes that the archives of the mission also are deserving of inviolability. And so a document that is in the archives of a mission has both the inviolability of an archive and the inviolability of a document. So there is some duplication. Now, what does this inviolability entail? The convention itself has a very ample regime regarding the content of inviolability. But one example that I think is very interesting is one case before the International Court of Justice. This was a case between Timor-Leste and Australia. And very unfortunately, this case never went to a judgment. It was settled outside of court before this could happen. And this is the reason why we don't have a definite pronouncement by the court on this issue. However, there is some pronouncement that is relevant in the preliminary objection. No, rather, it was the preliminary measures order. There's a mistake here in the slide. The precautionary measures decision by the court in 2014 and 2015. And in these decisions, the question that was presented before the court was that certain documents and certain data from Timor-Leste had been seized and detained by Australian authorities. And this related to communications between Timor-Leste and its lawyers in a pending arbitration that was between Timor-Leste and Australia. And so you can see how this can impact the sovereign interest of Timor-Leste, in the sense that the privileged communications between the state and its lawyers had been compromised, according to Timor-Leste. And so the argument by Timor-Leste was that there was a right under international law for the protection of property, the protection of lawyer-client privilege, and the protection of confidentiality under international law for official communications. So this was a very broad claim made by Timor-Leste. The court didn't pronounce itself directly on the existence of such duties, but it did pronounce itself on the effects of those duties. The court said that if these documents were, as Timor-Leste claimed, if they were protected by some sort of privilege or confidentiality, whether by international or domestic law, it was for a reason. The reason was that the disclosure of such information could be detrimental to the state, and it would be impossible to reverse. Once the information were in the public domain, it would be impossible to bring that cat back into the box. And so the court said that as a measure to protect the merits of the case, the court considered that Australia was barred under international law and by the measure of the court to use the documents. It was barred from presenting them, allowing them to be used, allowing them to be read, allowing them to be published in any time through any means. And so in essence, it meant that these documents could not be admitted in the arbitration between Timor-Leste and Australia. And of course, the reference here is not made directly to the protection only of diplomatic documents, but the analogy is very easy to be made, in the sense that the protection of these documents would allow for such documents not to be published, not to be disclosed, not to be shown to third parties, and not to be used to the detriment of the state that is the owner of the documents. Now, the Vienna Convention on Diplomatic Relations doesn't contemplate a definition of archive. According to Professor Bandera Galindo, the definition can be derived from the Vienna Convention on Consular Relations, which has under Article 1.1k a very ample definition. It encompasses, among others, papers, documents, correspondence, books, etc. If we see UNGA Resolution 77/108, which was adopted by the General Assembly on the 7th of December of 2022, very recently, the archives and documents under international law are protected in their various forms. And this has been interpreted as meaning that also electronic documents are protected. And very important in this respect is that the inviolability of documents does not depend on any marking. And so the question arises whether an unmarked document is entitled to inviolability under international law. The answer is that it is entitled to such inviolability, because as I mentioned under Article 40 of the Vienna Convention, the documents are entitled to protection everywhere and at any time. The problem is that because they are unmarked, there may be instances in which it is difficult for the state in good faith to identify them as diplomatic documents until they are read, until its content is revealed. And so the only way to know that you have violated the obligation is in a somewhat paradoxical way to violate it. And so this was answered by the Ethiopia-Eritrea Claims Commission regarding claim number 8, which concerned the protection of official documents. And according to the Claims Commission, the standard to be set in individual cases is that the state is obligated to return the documents and to protect them from outside interference, from outside disclosure and outside publication, as well as from the prying eyes of third parties, as soon as the official character of the document becomes apparent. And so once the official character of the document becomes apparent, then the state's obligation to protect that inviolability is triggered. And if the state, being aware of that, continues to use the documents, continues to present them, to disclose them, to publish them, or in any other way to use them, then the state is violating the inviolability under customary international law. Now, what about correspondence? So this is a simpler question. Correspondence under Article 27.2 of the Vienna Convention on Diplomatic Relations is protected. And as you can see, it refers to the protection of diplomatic correspondence. As I mentioned before, diplomatic law is aimed at the protection of the freedom of communication between the mission and its sending state. It is intended to promote the communication and friendly relations between states. And therefore, the protection and the inviolability of correspondence is an essential aspect of the functions of a mission. And therefore, this is what justifies granting correspondence a very ample protection. There is no need under international law for correspondence to be marked in any way. And perhaps here we can draw once again the analogy to documents, in the sense that once the official character of our correspondence is identified, then the state has the obligation to abstain from interfering with it, to abstain from reading it, disclosing it, and publishing it, or in any other way using it. Another point is that since the regime of protection for correspondence is so ample, it encompasses both communications from the sending state and to the sending state through whatever means are chosen by the sending state to do this. It also means that third states that are bound by this obligation under customary international law are also obligated to protect the inviolability of correspondence, even if it concerns the communication between a state and a mission that is not in their territory. Once again, an obligation upon third states. And this is very important because it arises primarily in the context of the protection of the correspondence when there is concurrent missions that represent a broad spectrum of states. And so the protection of third states is also very, very relevant and very necessary in practice. And a pinnacle and an essential aspect of this protection as well is the freedom of communication. It is recognized as the most important of all diplomatic and consular privileges and immunities because it is necessary for the effective operation of the diplomatic and consular mission. One final aspect is the protection of the diplomatic bag. The diplomatic bag's protection is not clear in the VCDR as to its content. This has been developed subsequently by the International Law Commission through articles on the protection of the diplomatic bag and the diplomatic courier, as well as according to some obligations under customary international law, although this can be challenged in specific cases. So one salient aspect of the regulation of the diplomatic bag is that it is required under international law to show markings. These external markings protect the bag. Now, what happens if a bag doesn't bear these external markings? Well, perhaps the bag can be opened, but the contents of the bag would continue to be subject to the broader range of inviolabilities recognized by diplomatic law. So, for example, if you have a diplomatic bag that is full of documents from the diplomatic mission, the fact that the bag is not protected doesn't mean that the documents cease to be protected as well. As I mentioned, the documents are protected anywhere and anytime. Now, the duties that arise for the territorial state in this respect is to protect the bag from third-party interference, as well as to abstain from interfering itself with those functions. And one important aspect that is born out of practice, but that is not as clear in law, is the notion of the right of retortion. And you can see that my computer is primarily in Spanish, so it decided to add an accent in retortion. But yeah, the right of retortion, also called the practice of challenge and return, or the scheme of challenge and return. So what is the logic behind this scheme? The logic behind this scheme is that the state is not entitled to open the bag. The state is not entitled to gauge its contents. But the state does have a regulatory and executive power to ensure that the diplomatic bag is not used for purposes that are illegal or that are contrary to the territorial laws. As I mentioned previously, the diplomatic mission has the duty to respect the territorial laws and regulations and not to interfere with internal affairs. And therefore, the practice that has been borne out with time is that if a state suspects that a certain bag contains prohibited contents, that state can challenge the bag. It can ask the members of the diplomatic mission to open the bag in its presence. And of course, this is not a legal obligation. The diplomatic mission is not obligated to open the bag. And the territorial state is also not entitled to open the bag. And so the diplomatic mission is entitled to refuse to open it. Because, for example, it may consider that the contents are according to law, and that if they were to open the bag, these contents would be violated in a contravention with international law and the interest of the sending state. And so if the diplomatic mission refuses to open the bag, then the state can refuse to accept the bag into a territory. In other words, it is a question of whether you open the bag or it is sent back. Why? Because the obligation under international law is to respect the content of the bag. But it is difficult to find in customary and conventional international law a duty to accept the bag, a peremptory duty to accept the bag. And so the state can, and in fact, many states, for example, Bahrain, has a reservation to the Vienna Convention that safeguards this right, the right to return the bag. And as some authors would say, this is a very unfriendly act in diplomatic relations, but it is not illegal because the state is not opening the bag without the consent of the sending state. And the final question regarding the diplomatic bag is the question of scanning, the possibility to scan a bag. The answer in the international practice is not very clear, although if one were to base oneself in the principles that inspire diplomatic law, one would say that scanning a diplomatic bag would be contrary to international law because it would be a way to gauge the contents of the bag. And in fact, the better practice is to subject the diplomatic bag to special, let's say a special protective regime where the contents are not disclosed, are not violated, but the interests of the territorial state are respected, such as the challenge and return scheme, which has gained some traction in some states. Now, the question that arises here, and this is something that permeates the whole question of immunities, is what happens when an immunity is abused. Now, for those that had the opportunity to receive yesterday's class, taught one by a dear friend on the question of state responsibility, one of the essential concepts in state responsibility is the concept of circumstances that preclude the wrongfulness of certain internationally wrongful acts. In other words, the concept of circumstances precluding wrongfulness, or CPWs. As you may know, under customary international law, only 6 CPWs are recognized. And these are set out in the ILC Articles on State Responsibility. Those are essentially self-defense, countermeasures, consent, force majeure, distress, and necessity. And so the question is whether you can use any of these circumstances precluding wrongfulness as a mechanism to carve out exceptions to these immunities. In other words, to carve out exceptions to the exception. And this is something that has been debated for a long time. So the first point perhaps is self-defense. Self-defense is recognized in Article 51 of the UN Charter. It is also recognized in Article 21 of the Articles on State Responsibility. Now, the question is whether in an armed attack or as a result or retortion to an armed attack, a state is entitled to bypass the inviolabilities of the mission, of the agents, of the documents, of the archives, or of the bag. Now, the aspect of self-defense causes some confusion, I believe, and this is also an opinion of many other authors, that the question is not whether you can violate these immunities in cases of armed attack by the state, because there will be no link between the alleged self-defensive measure and the armed attack, something that is required by the international law on self-defense. And so the only case in which you could actually try to argue self-defense to violate, for example, the inviolability of a mission would be if there is an attack from the premises of the mission. And so that you can repel the attack through the use of force. And this is very controversial. This is not something that is grounded in international law. And then one example of this is a case that occurred in the Libyan embassy in the UK. This was the case of Yvonne Fletcher. She was a police officer in the UK as a result of a very loud protest, very forceful protests outside of the Libyan embassy. An agent inside of the Libyan embassy, who was not disclosed, shot at the public, the manifestation. And the result of this was that a police officer from the UK was shot, and she died as a result of her injuries. And so the UK rejected this act as a violation of the right to life of the officer, as well as an abuse of the mission's immunities. But the UK didn't enter the mission. Rather, they asked for the Libyan government to disclose who was the person that had perpetrated this act. And as I believe, if I remember correctly, the result of this was that for some time, diplomatic relations between the two states were strained. But this was never characterized as an act of self-defense, but or a situation in which the UK could exercise self-defense in response to an alleged armed attack by the mission. And you have to notice in this respect that the requirements for self-defense under international law are very strict. You can see this, for example, in the Nicaragua case, in the oil platforms case, in the Wall Advisory Opinion, or in the armed activities case, where the court says there needs to be an armed attack. An armed attack is not anything. An armed attack is the sending of troops, either regular or irregular, on behalf of a state, and simply using force, or allegedly using force, in contravention of domestic law from the mission, doesn't rise to this threshold. And even if it did, you would still need to abide by human rights obligations, the requirements of necessity and proportionality as well. And so it is not clear that this is that self-defense is recognized as a means of setting aside immunities or inviolabilities. Another example could be countermeasures. Now, the question of countermeasures is very complex. Article 50 of the Articles on State Responsibility says that a state that is taking countermeasures is not relieved from the fulfillment of its obligations to respect inviolability regarding diplomatic or consular agents, premises, archives, or documents. This is stated in Article 50 of the Articles on State Responsibility. So in principle, you cannot use the suspension of inviolabilities as an action that is lawful as an act of self-defense, or rather as a countermeasure. And you have to notice what this refers to in particular. The example that is given in Article 50 of the Articles on State Responsibility is when a state violates another obligation and you decide to use the suspension of inviolabilities as a countermeasure against that international wrongful act. This is not permitted by international law. But the question is, what happens when the obligation that is allegedly abused is an obligation that is part of the diplomatic regime? For example, an abuse of the diplomatic mission, the diplomatic mission's inviolabilities, for instance, in the case of diplomatic asylum. And in this respect, the answer can be found in the ICJ's 1980 Tehran hostages case, where the court describes the regime of diplomatic law as a self-contained regime. And the way the court describes this self-contained regime is that the regime itself contains the mechanisms of redress. And the mechanisms of redress recognized under the law of diplomacy is the declaration of persona non grata and the breaking off of diplomatic relations. So any other countermeasure would not be allowed by the international regime. One can also mention other aspects, for example, distress or necessity. The question is rather complex, but perhaps the answer to this question is very simple. What can refer to the travaux préparatoires of the Vienna Convention and find that the possibility of resorting to necessity or distress, for example, in situations of emergency, as I mentioned previously, were envisaged during the negotiations of the convention, and they were rejected. So the attitude here seems to be that even necessity or distress are not recognized as exceptions to this inviolability. And this leads only to the last circumstance precluding wrongfulness, which would be consent. And here, the issue is that if there is consent, then there is no violation of the inviolability. So this is one can say that this is a snake that bites its own tail, in a sense, because if there is consent, there is no breach of inviolability. So consent doesn't really enter into this question when one discusses an internationally wrongful act in a legal sense, because there isn't any. So the final subject that I want to address is a very, very salient subject, very interesting subject, especially for those people who are connected in this session that are from Latin American countries. This is a very an issue that is very close to our culture and our political history. So the concept of diplomatic asylum has to be distinguished from territorial asylum. This is a distinction that was drawn by the ICJ in its asylum case. Because when one deals with territorial asylum, one is dealing with a person that is characterized as a refugee who escapes the territorial sovereignty of one state and enters another state. And so the question of territorial asylum doesn't involve questions of immunities, because you are in the territory of another state. And so what one needs to consider in this respect is human rights obligations and refugee law obligations regarding the treatment of such persons, as well as the obligation not to return them if they are in danger in their home country, the so-called principle of prohibition of return, or also called non-refoulement in French. And so there is no question of immunities here when one deals with territorial asylum. But diplomatic asylum is very different. Diplomatic asylum refers to the situation in which a so-called refugee or asylee, or also basically a common criminal, enters the premises of the mission of another state within the territory of a state that is prosecuting them. The best example of this is the case of Victor Hugo de la Torre, which was presented to the ICJ in the 50s. This was a person that had tried to overthrow the Peruvian government. He failed, and then he was prosecuted for what Peru called common crimes, not political crimes. And so in response to this prosecution, in order to protect his own integrity, Aya de la Torre went into the Colombian embassy and claimed asylum. And Colombia granted this asylum. And in fact, Colombia asked Peru to grant safe conduct to Aya de la Torre to leave Peru and go to Colombia, and so transform diplomatic asylum into territorial asylum. And so to solve this dispute amicably, both states referred the dispute to the ICJ. And so to understand the concept of diplomatic asylum, one needs to understand its historical background. And to understand its historical background, one needs to distinguish between the position at the universal level, at the universal stage in international law, and in the regional stage in Latin America. Because Latin America has a very long history of regulating circumstances in which diplomatic asylum can and may even have to be granted. You have, for example, the 1889 Treaty on Criminal International Law, which did recognize some form of diplomatic asylum in an unequivocal way. You have the 1928 Havana Convention, which was amended in 1933. You have the 1950s asylum case, which concerned this issue, as well as the Aya de la Torre case, which was subsequently, as well as the 1954 Caracas Convention on Diplomatic Asylum. And so the question of diplomatic asylum is not simple, because when one looks at the regional context in Latin America, there is this ample history of it. There is a recognition that in some instances, diplomatic asylum is necessary to protect political refugees who are being prosecuted for political reasons, and therefore they can be subject, if not protected, to arbitrary action by the territorial state. And so diplomatic asylum arises in some way as a mechanism of political pressure, but also as a mechanism of humanitarian protection. But when you look at it from the universal perspective, the perspective is reversed. In fact, in the 17th and 18th centuries, particularly in Europe, the exercise of, or the use of the inviolability of a diplomatic mission premise was considered to be a right that needed to be limited within very specific parameters to avoid abuse. There were concepts like diplomatic quartiers, where the inviolabilities of missions were extended to whole quarters of cities in order to allow for little pockets of the city where the territorial laws could not be applied because of the protection of the mission. And so this lent itself to a lot of abuse. And so the perspective from the universal, in the universal sphere, is rather the opposite, in the sense that the inviolability of the mission premises was seen as something that needed to be regulated very strictly to avoid abuse. And so the Aya de la Torre situation forced the court to look at these two differing perspectives and try to reconcile them. And so the way the court decided to reconcile them was by analyzing, as we did in this lecture, the issue of diplomatic asylum and the exceptions to inviolability as an issue of jurisdiction, particularly the issue of criminal jurisdiction by the territorial state. And why did the court did this? Well, the reason is very simple. The reason was that the 1928 Havana Convention, which was the legal basis that Colombia used to grant asylum in that case, did not expressly confer upon the asylum granting state the capacity to unilaterally characterize a crime as political or not, or rather as political or common. This was important because asylum could not be granted in respect of common rights, common crimes, because asylum was not contemplated as a mechanism to simply derogate from criminal jurisdiction. It was a mechanism to protect against political arbitrary action. And so the only way in which asylum could be granted if the crime that was charged was a political crime. And of course, the territorial state would say, as Peru did, that the crime was common, while the asylum granting state would say that the crime is political. And so since the convention doesn't say who is right, who has the right to characterize the conduct as criminal, as a common crime or a political crime, the court said, well, this is an issue of who has jurisdiction. If this is an issue of who has jurisdiction, the presumption that we need to start from is that the territorial state has jurisdiction. So Peru has jurisdiction. Peru can characterize this conduct as its internal law says. Peru says this is a common crime. Now, the only way in which Colombia could say that it is derogating from this right is by saying that there is a rule under international law that allows it to derogate from such criminal jurisdiction. That would be the only way. In other words, the only way in which the asylum could be granted in that situation was if, under international law, Colombia could be recognized as exercising criminal jurisdiction. And so for the court, it was very simple. If Colombia could not claim this right under international law, then it meant that the characterization by Peru was binding. And if the characterization by Peru was binding under international law, then the derogation that Colombia was trying to do by granting asylum in contravention to the 1928 Havana Convention of asylum to Aya de la Torre would be a violation of international law itself, because it would be to interfere with the ordinary functioning of domestic criminal tribunals and domestic criminal prosecutors. And so the court said that since the crime could not be considered to be a political crime, or rather a common crime, according to Peru, then, and since you could not demonstrate the kind of arbitrariness that Colombia was claiming, then the granting of asylum was irregular. What happened after this was that the court said that the asylum granted by Colombia needed to cease, but the court didn't say how. And so when the court handed down its decision, a new dispute arose between the parties as to whether Colombia was, in fact, obligated to turn over Aya de la Torre to the Peruvian authorities, or whether the asylum could be terminated in any other way. For example, by taking Aya de la Torre into its own territory. And so, once again, Peru and Colombia went to the ICJ to solve this dispute. And before the ICJ, the court basically said, listen, it is not my function to solve this dispute politically. I am only here to state the law. The law says that this asylum needs to end, but it doesn't say how. And therefore, it would be repugnant to the object and purpose of the Havana Convention to say that when asylum is irregular, the state is obligated to return the refugee to the authorities, because there are many other ways in which an irregular asylum can be put to an end. And so the court mandated that it would be up to the parties to solve this from a political perspective. And that's how the law was stated in that case. So for the ICJ, the question of diplomatic asylum is a question of interference with domestic affairs, something that is a concept well rooted in diplomatic law, and also a question of jurisdiction, which, as I mentioned, is the theoretical underpinning of the question of diplomatic immunity. Now, when we analyze this perspective, this 1950s perspective by the ICJ, from the lens or through the lens of current practice, one could say that this approach is no longer as appropriate as it was then, because there is extensive practice in which states have granted asylum. Of course, there have been objections as well, but there is a recognition that at least the territorial state is not entitled to enter the embassy. The territorial state is not entitled to suspend the inviolability of the embassy. And therefore, so long as the inviolability is still being used, is still being exercised as a function of the mission, then de facto, the diplomatic asylum could be maintained. So in the end, it appears that diplomatic asylum falls within the question of inviolabilities. And at the same time, the question of refugee law, the question of extradition law, has become intertwined with the issue of human rights. As I mentioned before, there is a principle that says that one cannot return a refugee to a country where that person is going to be prosecuted. And the crux of the issue here is that under human rights law, something that you would analyze with a lot more depth tomorrow when analyzing human rights law under international law. Under human rights law, the question is whether the state has jurisdiction over the human right in question. So the state has jurisdiction in its territory, as the court said in the Wall Advisory Opinion. I mentioned this previously. The court said, here it is, that the jurisdiction is primarily territorial in the human rights perspective, but it can be exercised extraterritorially. For example, the European Court of Human Rights says that there are further mechanisms for exercising human rights jurisdiction. For example, when there is effective military occupation, or in situations in which there is a public official that exercises public functions for the state in the outside of its territory. And so if one recognizes that human rights jurisdiction can be exercised extraterritorially by a state, then the only question is whether a consulate or an embassy is a situation which would allow for such extraterritorial human rights jurisdiction. If that is the case, then principles such as principles of refugee law, principles of non-refoulement, principles of non-return, principles of extradition would suddenly be relevant for the diplomatic mission. And if that is the case, then asylum doesn't just arise as an issue of whether the state is entitled to grant it, but whether the state is obligated to grant it to protect the person's rights from arbitrary state action. So, as you can see, the evolution has been rather drastic. I would not say that the position based on human rights is well established in customary international law. I would not go so far. And in fact, I would say that the best evidence that it is not part of customary international law is the fact that the Inter-American Court of Human Rights stated in its advisory opinion regarding asylum that asylum is not a human right in the context of diplomatic asylum. And if it is not a human right in Latin America, where the Inter-American Court has jurisdiction, then it is very difficult to say that it would be applicable as a human right anywhere else. But as you can see, this is a very complicated question, one that is not yet settled. There are other salient questions. For example, there is practice in embassies, but can you grant asylum in a consulate? Can you grant consular refuge? It's not easy to say. And so this is an issue. Diplomatic asylum is an issue that raises more questions then it gives answers. And I would actually encourage you, if you're interested in it, to look deeper into it, because it is a very important and a very interesting issue of international law. And so with that, we will conclude this session on diplomatic and consular law. I don't know if there are any questions. I don't see any question in the chat unless I am missing anything. So if there, I think I see a hand. No, I think it's just a pause. Okay.
Understood, sir.
Go ahead. Brian, did you open your mic?
Yes, thank you. I say that everything is understood. Thank you.
Oh, great. Excellent. So in any case, if there is any question, you can send it to myself or to Claudia, who, as I mentioned, we are co-administrators of the Jessup competition in Guatemala. And we are also the organizers of this course. So if you have any questions, you can send it there. Otherwise, with this, I will conclude the session. I thank you for getting connected to this course, and I hope that you enjoy the rest of the Latin American Jessup School. Good night and goodbye to everyone.
Actually, just had a brief question on whether, on just how, thank you. It was just on, like, I know that this meeting is recorded. Is there anywhere you're publishing these videos, or is it just for like administrative purposes?
Oh no, they will be published. I believe at the end of the whole school, they will be published. We are not yet sure where, but they will be published. So when this is done, we will send you an email so you can go back and see the videos.
Perfect. Thank you.
You're welcome. So anyway, with this, we close the session, and I hope you have a fruitful Jessup School. Good night.